So I want to offer a few brief comments to draw together these three distinct, but I think importantly interconnected papers, and then turn over discussion to the audience in response. Centenaries are odd things. As historians, we tend to be skeptical of the idea that human experience presents itself into neat 100-year packages for our analysis. But it's not every year that we get an octocentenary. What will this century's reevaluation mean for Magna Carta? We might start by considering the reevaluations of earlier centuries, but there just aren't many. I can find no sign of a centennial reflection in 1715 or any 15 before that. In 1815, we find no signs, I found no sign, of reevaluation, but there was certainly celebration of a quite restricted kind, and quite like Linda was pointing out, of a very conservative medieval kind. A 21-day fete hosted by the Duke of Norfolk at Arundel Castle. He built a Gothic hall just for the occasion. He invited the finest guests, the Prince Regent, the Knights of the Garter, other leading gentlemen, who attended an opening banquet, of course, on June 15th, in period costume. Toasts were given to the fair company and to the Duke of Wellington. Just 3 days later, they didn't know this, he would be besting that quite un-English person, Napoleon, at Waterloo. There was then a big ball after the dinner, followed by days of tournaments in the ancient style, as newspapers reported. The whole affair, then, was less a reevaluation of Magna Carta than a celebration of Gothicism, as the aesthetic associated with the peculiar wonders of Englishness, hardly enlightened or revolutionary. In 1915, celebrations were quite muted, focused as everyone was on the battle then being fought between English liberty and its German nemesis in the fields of France and Flanders. More interestingly, though, in that period, editorials that month in the Times of both New York and Los Angeles described a major U.S. District Court decision not to break up U.S. Steel as, and I'm quoting here, the Magna Carta of good business. There's no reference to Chapter 30 here, but I think Professor Holzbosch is onto something. So in 1815 and 1915, Magna Carta was understood as strictly a limited national or Anglo-Saxon good. What a difference a century makes. Here in 2015, when everyone, of course, has gone global, we discover that Magna Carta might be deployed on behalf of peoples around the world. As these three papers show, it has long been thus. How can this be? The answer may be found, I want to suggest, by examining both halves of the expression Magna Carta, or Great Charter. There's a charter here, a text, but there's something else too. A transcendent reach for greatness, that magna, inspired by a relic whose text has all but faded from view. This extra-textual greatness has, since the 18th century, made Magna Carta the means by which people everywhere have asserted broad rights claims and sometimes realized them in the design or redesign of their polities. Now, Professors Colley and Travers' papers highlight Magna Carta's plasticity arising from this bare, detextualized greatness. As Professor Colley's 1848 Observer reminds us, the Charter was even then generally talked of in utter ignorance of its contents. Much cited but little read, as Professor Travers nicely put it. I think this is right. A diffuse idea of greatness has long mattered more, especially in Magna Carta's global walkabout, than have any words, including that most famous portion of the text concerning so-called free men and their procedural privileges. Without, I hope, being too cute, we might say that it is the Magna rather than the Carta that has done the serious work for the last 2 or 3 centuries. But this is not entirely the case, and I think as quite importantly, as Professor Holzbosch has reminded us in his reading of Chapter 30, that the text itself has continued to matter, may point to very different legal and lay uses of the Charter. So I think it's quite significant that the close reading of the text appears in litigation and a court's consideration of a problem, as opposed to the political work that it's doing in the papers of Professors Colley and Travers. Even considered strictly as a text, Dan reminds us that Magna Carta had an extra national character from the beginning. Chapters 10 and 11 of Magna Carta concerning debts owed to Jews. Chapter 1, concerned with the church, the first great transnational corporation, suggest exactly the same thing. Taken together then, Chapter 30 and these other clauses remind us of the transnational permeability of what is too often considered or read as simply a statement of proto-nationalist legal political ambition. Later readers understood this transnational permeability well. Even Sir Edward Coke understood this, presumably among the most insular devotees of the ancient Constitution. Holzbosch's Coke, then, is a surprise. In Cook's reading, Chapter 30 reflected a peculiarly English genius for promoting English engagement with the world. This recognition informed Montesquieu and Blackstone and Alexander Hamilton and his peers, who imagined what I love, a fiscal commercial federal state resting on the principle of reciprocal recognition of trade among nations. The use of Chapter 30 in some of the U.S. Supreme Court's first cases, literally among their first cases, now makes perfect sense and suggests how Dan is on to something critical as he asks readers of the U.S. Constitution, a more insular bunch than even was Sir Edward Coke, to see many other signs of how our Constitution calls us and our laws to interact with the laws of others. The people Professors Colley and Travers bring into view likewise called for one nation's laws to interact with the laws of others. Doing so by invoking Magna Carta meant moving beyond the text to the greatness associated with a relic. To see how they moved beyond the text to relic, how they did this, let's return to that 1915 editorial praising the Magna Carta of good business. Now, watching this locution, the Magna Carta of, fill in the blank with whatever it is that you want to exalt, watching this locution evolve, we can follow a rhetorical transformation that I believe explains how the actors in Linda's and Robert's papers asserted what they did over the centuries as the text itself receded from view. This usage, Magna Carta of, fill in the blank, began in the late 16th century. Scripture was often described as Magna Carta in countless sermons. But the Magna Carta of formulation also referred to non-texts, even to quite pure abstractions. Faith was thus the Magna Carta of the soul. There was a Magna Carta of Christian liberty, a Magna Carta of nature, a Magna Carta of heaven, and even a Magna Carta of hell. Magna Carta thus became a marker of the most abstract claims and of their association with greatness of the most evanescent kind. If heaven and hell had a Magna Carta, why not Hindustan? Edmund Burke's formulation thus fit nicely into this rhetorical transformation that occurred over the preceding 2 centuries, by which a vague, if powerful, aspiration for greatness came to be expressed. Little wonder that Burke, Fox, and others used Magna Carta to inspire a reach far beyond Englishness, the Englishness of the original text. English rights thus became human rights. Burke was as aware as anyone of the danger as well as the opportunity as the national went global, that the protection offered by a form of laws made in England for non-English peoples to protect them from the tyrannies of local rulers and those of one of the first great transnational corporations might become the instrument of a new kind of tyranny. But in using the magical language of Magna Carta, I love Price's condemnation of the witchery of words. Using the magical language of Magna Carta, Burke could put aside his worries. And I think Burke is evoking what Linda was talking about as an almost totemic material object. The materiality of the thing, even more than the words in it, really is what is mattering. If Magna Carta then was more relic than text, we can readily understand the frustration of Edward Shepherd Creasy when he complained in 1848 that Magna Carta was on everybody's lips but in nobody's hands. But as Linda reminds us, it was precisely this quality that made Magna Carta a resource for virtually all claims making by everyone, everywhere. Like a cross or other potent religious symbols, the bare words, Magna Carta, carried a force that everyone might read, even if they read into them quite different meanings, as indicated by the very different meanings of Magna Carta offered by everybody between John Wilkes and George III. As Linda shows, attention in print to the idea of Magna Carta, if not to its text, rose in the mid-18th century. Indeed, we might conclude that it is the shift of attention from text to relic that contributes to this increased invocation of the Great Charter and thus ultimately to its global mobility. Yet for all the references to what was increasingly understood as a foundation to the history of others' constitutions, Britain remained outside the practice, as Linda reminds us, of constitution writing that gripped so many other polities in the late 18th and early 19th centuries. This might seem like a paradox, but I think it might be resolved by pointing back to Magna Carta's two aspects: its life as an actual text, a text perhaps of greater interest to lawyers, judges, and litigants, as suggested by Dan's paper, and its use to assert vague ambitions in support of rights claims, a greatness of more interest to political leaders and those they hope to lead, as suggested by Linda's and Roberts. Whether in legal or lay hands, whether as text or relic, Magna Carta has always operated in a transnational and even in a global dimension. As Linda reminds us, Magna Carta remains widely unread, even misread. Therein, of course, lies its power. So, with that, I want now, we've got a nice amount of time to throw the discussion open. Perhaps, though, it might be nice to start with the three of you, if each of you would have anything you might like to say in terms of what the conversation among the three papers has provoked. Do any of you have any initial comments before I open the floor that you might like to make at this point?
I would actually say that you mentioned the 1915, the 700th birthday of Magna Carta. It's actually a very interesting period which could do with a good analysis, precisely because the First World War is going on around them, you get some really interesting takes on Magna Carta by various iconoclastic and radical voices. So you get people arguing for a more federal Britain once peace comes, a more federal empire. You get quite a lot of women's suffrage arguments in 1915, again from a deliberate misreading or partial misreading of Magna Carta. Magna Carta makes some provisions for widows, and from that, some women's suffrage activists move to an argument that the Latin word homo should be read as including women, and that therefore they produce a very complicated rereading of the Golden Passage to bring Magna Carta into the women's suffrage argument. And I think a lot of this is happening quite deliberately under the fire of war. And these arguments could very profitably be coaxed out. They've been forgotten.
Dan,
Well, I just wanted to pick up on a comment that Linda made about soft power, the uses of a written constitution and soft power, because I think this speaks to, again, Burke's idea of this being a Magna Carta for Hindustan, speaks to this idea that the conquest of India may not be achieved by force. It can be achieved, I think part of when he puts this very broadly and says this is not just the Magna Carta of Bengal, which has been conquered, but the Magna Carta of the whole of Hindustan, most of which has not been conquered formally and is formally ruled by the company. I think there's an imaginary here, which is a very, very powerful imperial fantasy, which lasts into the 19th century, that India had not actually been conquered. Macaulay says this quite explicitly in the 1840s. India was not conquered by force of arms, but by the force of, he says, the yea or nay of a British envoy. That in other words, British truth-telling, British diplomat, the security of a diplomatic relationship with Britain had attracted Indian states like bees to a honeypot. And this fantasy of an empire of soft power, together with the fantasy that you could conquer a territory and it would be self-governing, it would have its own constitution, and so Indians could be self-governing even within the empire. These were two very, very important imperial fictions that I think originate in the late 18th century, but have a very important life in the Victorian Empire.
There are some nice parallels to that in the U.S. Constitution as well, the way that the constitutionalism spread across the continent with the equal footing doctrine. And but I want to put that aside. I'm trying to grapple with Paul's separation of the political and the legal Magna Carta. And I think there's something right about it and also misleading. And I'm trying to figure out how to express what I think might be I think often when we as historians look back at historical actors' use of these magic words and, these great terms, we think that, it's a grab bag. They're just trying to draw on the authority of that term without making any real attempt that has any integrity to link the use they're making in time A with the use in time A minus 100 or 800. But with lawyers, as with, I think, political operators who have legal training, which may just bias this toward the U.S. or something, but it's used a lot. Magna Carta is invoked a lot in the early Republic. And I do think that they are doing something other than associating their fundamental law claim with some historical notion of greatness. I think they're trying to make the claim that there are structural similarities across time, that that if you ratchet up some level of abstraction, what King John and the barons were doing, that's what Georgia and the U.S., that's the connection. They see some real structural connection there that isn't just mysticism, but they see like a transcendent meaning in some of these basic power relationships, and they're translating that old negotiation into a new one. I mean, I do think, yes, often it's Magna Carta terms like this, they're just invoked in a haphazard way to try to give some patent of authority to a rights claim. But I also think that a lot of these papers are actually trying to think deeply about the connection of doing government and what it means to make an agreement. And how do you make a promise that's supposed to be fundamental but then renegotiate it? And what's the connection between the renegotiation and what you had before? I mean, there are a series of real steps that I think that they're trying to work through. So I have to think more about this, but as always, a very elegant and thoughtful comment.
So, turn it over to the audience, please. Lisa.
Thanks so much. That was just so interesting. And this is a poorly formulated question, so forgive me. It's mostly to Linda and to Robert. Professor Colley and...
Can't hear.
Can you hear me at all?
Do you want to stand?
Yeah, I'm so sorry, but with the air conditioning.
That's terrible, that's fine.
Might help for the rest of the
What
audience.
strikes me as interesting as someone who's writing a little bit about the British Empire at the moment is the reticence of Britain to take on the problem of the Constitution itself, at the same time as it's sort of obsessively in the early 19th century trying to figure out what the Constitution of its various colonies might look like. And how that pans out, and I think this might speak to the reticence a little bit, is through reconstitutional courts and thinking about fair trials in the different legal systems. So I wondered if you could comment a little bit on the disjuncture between sort of central reticence and peripheral obsession with constituting and thinking about constitutions and fairness, which in terms which are very prevalent in that 29th chapter, of the Magna Carta.
By central reticence, you mean not producing a codified constitution at
For
home?
itself, yeah.
Yeah. I mean, obviously this is a hugely complicated as well as very good question. I'm not sure the British state would necessarily have accepted the tension, because after all, there are certain overlaps between charters and written constitutions. Obviously, someone like Hamilton and Madison want to sort of push those two aside and separate very much, even more does Tom Paine. But there are certain overlaps between charters and written constitutions. And there are continuities there that first the English, then the British, when they're developing colonies in the 17th and the 18th century, increasingly issue charters for them. And they continue to do so, of course, after the age of constitutions starts. But what is interesting, I think, or one of the interesting aspects, because it shows again how the British are adapting to global trends. Increasingly, imperial charters are called by the British themselves constitutions. So when they issue effectively charters to New Zealand and Australia in the 1840s and 1850s, these are called constitutions or constitutional acts. And in fact, of course, the British are themselves imperial reformers by the 19th century, are monitoring very closely what the US is doing with state constitutions to forge its own westward expansion. And you get various British imperial reformers drawing interesting comparisons between the United States' use of state constitutions to forge continental-wide empire, and how the British are going to use renovated charters to keep their settlement empire together. So I think the sort of interlinking of constitutional thought across the Atlantic, and the way in both cases actually constitutionalism is feeding into different modes of empire is fascinating.
I would just say that, thanks, Lisa, for the question. I would just say that the striking thing to me about the debates about India is how much the parliamentary debates and the debate in London is all about the British Constitution, not about India. So my question as I approached this, the Fox's India bills, was how would this have changed the government of the empire in India? But all the political discussion was, how is this going to change our domestic government in Britain? How is, for example, having this group of commissioners with all this patronage power over India, all this imagined wealth that they would have in their hands, the ability to give jobs to people, this would create this new potentially corrupt force within the realm, which would rebalance the British Constitution, take power away from the king, take power, people were concerned about, having basically Fox's own party having this, you could think of this as like, electoral financing, having a lockdown on financing of elections because they had the power of the Indian Empire in their hands. So I think that the debate, what the India debates did was make people focus obsessively and anxiously on how to preserve the balance of power within the realm against these new sources of power and wealth from outside the realm. And I think that that's very important in explaining the outcome, because the outcome is what I think of as this structure of an insulated empire, where the goal is to insulate the domestic state as much as possible from the effects, not only the effects I've just described in terms of new sources of power, but the potential destabilizing effects of having every political crisis in India be a political crisis in London, which would be a nightmare. And so the structure was very carefully calibrated, I think, to try to protect the domestic constitution from and separate out the colonial constitution from the domestic. Of course, having the empire being so far away was helpful in this regard. And Burke says one of his most interesting quotes about the Indian Empire was, in the Roman Empire, the subjects came to Rome. And he said, I've never seen an Indian in London. And this is so I think that.
Do you want to stand so everyone can hear?
Sorry, all four of you touched on directly and indirectly the idea of the Magna Carta, potential human rights document. And I have two questions in that regard. One extent to which the Magna Carta, this kind of invented tradition of the Magna Carta, is about constituting a transatlantic or imperial community against the European continent, against whether it is a continental despotism or the continental revolutionaries' rights of man tradition. And the second aspect is the extent to which these understandings and implications of Magna Carta track kind of domestic rights discourses and languages. So the transition from natural rights to historic rights, citizenship rights, or the extent to which Magna Carta is actually the opposite in the sense it's people kind of resisting these trends. It's very interesting how Burke, for example, that Magna Carta, is kind of about people invoke it as a kind of defense of historic rights. Right? So I guess those.
So I think there's a plurality of uses, and that's a nice way to think of it, as custom versus natural rights, I suppose. Of course, you see both. They even tend to intermingle. Some people are drawing on both. I don't see a lot, at least in the places I've been looking, of a distinction or an attempt to use Magna Carta to carve off a very peculiar Anglo-American community from the rest of Europe, at least in the revolutionary period, let's say. If anything, there's an opening up. There's a desire to repackage some of these, what had used to be seen as customary rights, as connecting to other European systems, say when Benjamin Franklin hauls over the 13 state constitutions and a couple of, including a couple of colonial charters, and presents them as cutting-edge Enlightenment documents that can speak to France, to the Netherlands. So I don't see that particular juxtaposition there, but maybe my colleagues do.
I think there's change over time, as Dan is suggesting. Certainly in the late 18th century, you get lots of references to Magna Carta, for example, in the French Revolutionary National Assembly. Galicia creates its own Magna Carta in the 1780s and 1790s. So that the overlap with continental Europe is there, and it's understood to be there. But what I think is shifting is in terms of crude polemic. By the second half of the 19th century, as you get more stress on Anglo-American unities, you also get more complacency about Magna Carta. So Punch produces a cartoon when Napoleon III of France issues a constitution, and it shows Punch showing Napoleon III Magna Carta as something that he should really try to emulate, the implication clearly being that he can't. So I think as part of Anglo-American complacency, you are getting it much more by the end of the 19th century.
Yeah, just quickly on that, Burke specifically uses the term Magna Carta of Hindustan, not in an Anglo sense, but in a European sense, because he immediately also compares the bills to the Peace of Westphalia. So he's using this, I think, in a more cosmopolitan sense to refer to public covenants, a history of European public covenants, which are also related to the law of nations and to natural rights through that discourse. And I think one of the reasons why he's doing that is because one of the biggest fears that he and others have about the Indian Empire is that the company, by its militarism in India, will spark a war in Europe. And so part of his audience for his discourse about India is other European states saying, we are not going to let our East India Company drag the British government into wars with European states. We are going to make sure the law of nations is followed in India as it is in Europe. And so I think for Burke, it is a kind of Europeanist sensibility that he brings to Indian affairs.
Other questions? So just a moment, I'll come to you in just a moment. I'm sorry, I'm pointing here. Okay, I'll come back, right.
I'll try to ask quickly. I wanted to follow up on this question of the deliberate misreading that I think someone would touched on. I guess one of the things we can never always get at is intentions or intentionality, but I'd love to hear how you read the intentions or intentionality of your protagonists. Do you see them as understanding that they're interpreting or perhaps manipulating the Magna Carta as they're doing this? Or do you see that more as our current understanding of what they're doing as they're doing it?
I mean, when you're dealing with, so I dealt with some legal cases. When you have two sides, there's always someone on the other side saying you're misreading this or it's a misanalogy, and this is classic lawyers' reasoning, where one side will try to make a claim based on what looks like maybe not the most apposite analogy, but then ratchet up the level of generality. So if you look at this problem at the correct level of generality, I realize we're not dealing with merchants who happened to be in Georgia during the Revolution, but in the 18th century what we're dealing with are credit networks, and in a sense their credit is here, so they are there, and they keep making those. So they realize that there are disanalogies or ways that one could historically pry apart the actual article from their invocation of it 6 centuries later. But they don't think that they're trying to get away with something. They really do think, like, this is the way you make legal and political arguments. You try to analogize your situation today to something in the past, and that analogy gives some, in certain forums, extra authority. It also, one role of a chapter like Chapter 30 or the 3940 or 29, due process, is that they become illustrations that can be, not that these actually are binding laws that can be invoked, but they're illustrations, like anthropologically, of how former communities have dealt with similar power dynamics and resolved them in ways that we should think about, like protecting foreigners. When you start ratcheting up, Chapter 30 becomes like the protection of foreign interests. Is it a misreading, or is it a creative and compelling reinterpretation? I think it's if you try to think like the actors at the time, they really think they're doing something that has some integrity.
It's also the case that, this is a very old text. It was initially written in a very difficult form of abbreviated medieval Latin. Moreover, there's not just one version of Magna Carta, there's successive versions. And these aren't really reconstructed in a serious and quasi-scholarly way until the 18th century. William Blackstone famously produces his version in 1759, but in fact there's quite a scholarly set of work on it in the 1740s. So there's lots of options for misunderstanding or selective quoting. That said, and forgive me if I offend anyone, but what I was constantly being reminded of when I did work on Magna Carta was some of the reinterpretations and perhaps misinterpretations of Tea Party activists of the American Constitution, that if you have an iconic text, even if you read it very carefully, how you read it is likely to be subject to many variations. You may not be conscious, you may not see yourself as misreading it, but multiple readings of ancient iconic texts are very possible.
Yeah, and thank you for the question. And I would just say that the trans-historical structure of argument that you've talked to, that means that the Magna Carta of can be replayed again and again, and which is taking shape in this moment, is the basic structure is the structure of arbitrariness or the rule of law, right? That I think is the thing that plays repeatedly. And what's really interesting to me about the debates about the Indian Empire is that, so Burke says the Magna Carta of Hindustan because there's a tyranny that is lawless and we're going to replace this with a regulated form of empire. The interesting thing that happens is that the term despotism gets taken over from the tyranny side of the argument and put on the rule of law side of the argument. So in India, you can have a rule of law that is a despot. That's the company, the British Empire calls itself a despotism of law. And so one of the very interesting things that's happening in this moment is that within this structure of argument between arbitrariness and lawfulness, colonial despotism, as a form of enlightened despotism, is being rewritten onto the side of the rule of law. And that's what Burke ultimately rejects. I think he argues that you can't both have this massive executive power in the hands of the government, effectively unchecked by domestic control, and still be a rule of law. You may have laws, but this is not a rule of law. And you have to have publicity. You have to have checks and balances. And that's a very powerful, that'll be a constant kind of refrain in 19th century politics. But I think that's part of the essential framing of the Magna Carta of its arbitrariness and law.
Yes, there was a question before in the back. Yes, please.
How did the Magna Carta
Can't hear.
I'm sorry, can you speak?
Perhaps you could come forward. I'm so sorry, but it's so
This
noisy here.
blower up here is really remarkable.
Yeah.
How did the Magna Carta influence 18th century British thought? And also, how did the Magna Carta get referenced in the U.S. constitutions during the American Revolution? And finally, in the 1790s, you mentioned how the Magna Carta was cited in the U.S. Supreme Court. Was it influential for both Federalists and anti-Federalists? Because I remember from the quote that Empire of Liberty, Senator Thomas Jefferson said, the relation to Emmett Burke. So I just want to know how this question.
The first question.
Whig thought, 18th century Whig
Yeah.
thought.
Whig thought.
Sorry, could you repeat the first question?
No problem. How did Magna Carta influence 18th century British Whig thought?
Whig thought. Well, how long have you got, really? It influences it a great deal, though I do think that the chronology of the influence or the number of references to Magna Carta is quite a complex one, and you could trace it with much more precision than has been done. I would also want to say that I don't think it's just the nexus between Whigs and Magna Carta. I think there can be Tories and Conservatives inserting themselves into Magna Carta and inserting Magna Carta into their political argument, because again it is such a plastic text, because you can stress that this is a royal text approved of however reluctantly by King John, but after all subsequently reissued by later British monarchs and inserted into the statute book. So there is a respectable royal rendition of Magna Carta, if you want to emphasize that, or you can focus on the kind of reinterpretations of Magna Carta increasingly offered in the 17th century by men like Coke, and say, push monarchy to one side and stress much more the impact of the House of Commons, how this fits into Magna Carta. There's a lot of bad Whig history involved here. So how you use it changes over time, but it is there for the Whigs in a particular kind of way. And perhaps the most vivid way of saying that is the 1832 Reform Act, which is passed by a revived Whig political party. And some of the leading Whig actors in the Reform Act controversy of 1832 see this as a new Runnymede. Here are great Whig lords, a new set of barons, if you like, securing rights, a document of liberties for the people. And there is, in fact, a great frieze in Hokum, one of the great houses in Norfolk, England, showing the Whig lords securing 1832 Reform Act, but in the guise of the barons at Runnymede securing Magna Carta. So, there's lots of echoes there in political ideology.
So you ask a big question, Magna Carta in the Revolution and the Constitution. Let me just give you a couple of illustrations. When the Constitution was published in September of 1787, the soon-to-be-called, or anti-federalists, were outraged because there was no Bill of Rights. And I said, Magna Carta is like a Bill of Rights. How come we have no Bill of Rights? The Federalists shot back, somewhat opportunistically. They said, Magna Carta was a grant from the king. It's a gift. In fact, it has to be a gift. That's why it was annulled by the Pope. Because if it's seen as a treaty negotiated, it's void. So that's a grant. Now the people are sovereign, and we don't need a separate Bill of Rights. The Constitution is our Magna Carta. So that was one way of that the Federalist, Anti-Federalist divide played out. It became one of the ways they talked about popular sovereignty. As far as the Revolution, when the Stamp Act and the American Revenue Acts are passed in 1763, 4, 5, a lot of colonists start arguing, well, we ought to be protected by the Magna Carta, especially no taxation without representation, which you can kind of find in Magna Carta. And this resonates across the Atlantic. Pitt famously was taking a bath, I think in Bath. It was said when he heard that the Stamp Act had been passed, he rushed back saying, the colonists must have their Magna Carta and their royal colonial charters, and this is depriving them of representation with tax. It's taxing them without representation. So there are a lot of high-profile moments where it's involved. But the idea of the grant and its relationship to popular sovereignty is very interesting in 87, 88.
I think the first paper money issued by Massachusetts in the American Revolution bears the sign Magna Carta.
Thanks for the question. I just want to go back to your first question about the role of Magna Carta in Whig thought, because Burke's was in this way, I think, a classic Whig, in that he understood Magna Carta as having secured or consolidated the rights of Parliament, the right to a government, royal government by the consent of Parliament, and therefore the 1688 revolution had further consolidated the original gains of Magna Carta. And I think, therefore, that he interpreted the rise of the British Empire in India as a dangerous backsliding from the 1688 revolution, from the revolution which secured limited monarchy. He understood the British Empire in India, or the Company's empire, as a form of absolutism, harking back to the Stuarts in the 17th century. And so the question, therefore, was how to create limited government in India. And his solution was make the Indian government properly responsible to the British Parliament. If there was no Parliament in India, then one could make the Indian executive responsible to the Parliament of England, and in that way reinscribe Magna Carta and the 1688 revolution into the Indian Empire.
And on that note, we've run out of time, but I want to encourage you to be in touch with our authors or look for them this weekend to continue what has been a marvelous discussion, and join me in thanking them, please.